a draft omnibus bill, the Equality and Religious Freedom Act proposal. And this is to serve as a starting point on what does or what could full federal equality look like if achieved by Juan Ehonen-Jover and Ken Ehonen-Jover of Equality Giving. And that's also their website, equalitygiving.com. Drafted by Lane Hudson, a civil rights attorney. Religious Freedom Act. Purpose, again, equal protection under law via amending the civil rights laws, include LGBT and preserve religious freedom at the same time. The assumption in crafting this bill was that amending the existing civil rights laws is preferable to creating a separate standalone legislation, and that's the attitude that's maintained when making this proposal here. Written in a general form of a statute, additional proofing, of course, resolution of details that could come later as this thing goes to Congress, and those who have experience in writing the law make the necessary details possible. So this bill would cover, but not limited to necessarily, equal employment opportunities, fair housing, places of public accommodation, use of public facilities, equal credit opportunity for same-sex partners, federally funded programs and activities, protections in education for those who have disabilities, marriage equality and religious freedom, protection against hate crimes, protections for those serving in the armed forces, and protections for those who wish to immigrate. Section A, equal employment opportunity, which amends Title VII of the 64 Civil Rights Act, which is to add and define sexual orientation and gender identity so that gay people are protected in employment. And also amends the Civil Service Reform Act of 1978 and the Government's Employees' Rights Act of 1991. And it does the same as above. So taking several laws at once and bringing them all to say the same thing. Keep everybody on point. Keep every rights act on point. It also amends the Family and Medical Leave Act of 1993, defining what is a parent, son and daughter, and spouse for federal language. A parent is a biological or de facto psychological parent of a child who happens to be an employee. The son or daughter is to be defined as biological, the adopted, the step son or daughter, ward, or dependent under the employer's domestic partner policy, or the employee and her or his partner. The spouse is to be known as the husband, wife, domestic, civil union partner, domestic and or foreign marriage partner. And all these, everything I just mentioned will be amended so that in every instance where the phrase race, color, religion, sex, national origin appears in the statute, it shall be replaced with the phrase race, color, religion, sex, national origin, sexual orientation, and gender identity. Section B, fair housing. Amends Title VIII of the Civil Rights Act of 1968. Also known as the Fair Housing Act. It adds sexual orientation and gender identity to mean what I just described before. Protect from discrimination in housing, sales, renting, real estate transactions, and any discrimination in the provision of brokerage services. Section C, places of public accommodation. It amends Title II of the 64 Civil Rights Act, adding, again, sexual orientation, gender identity, under the same definitions as I mentioned, to protect from discrimination or segregation in places of public accommodation. Use of public facilities, amending the 64 Civil Rights Act, again, add sexual orientation, gender identity, protecting LGBT from discrimination, denial of equal use of public facilities. Section E, equal credit opportunity, amends the Equal Credit Opportunity Act of 1974, originally, of course, to protect women and, of course, people of color from discrimination in handing out credit, giving up credit, redlining, of course, adding sexual orientation and gender identity. Again, protect LGBT and their partners from discrimination in any aspect of a credit transaction. And yet, the phrase that we put in race, color, religion, national origin, sex or marital status, sexual orientation, gender identity, or age. Those will all be included for protection. Federally funded programs or activities. This amends Title 6 of the 64 Civil Rights Act. Again, sexual orientation, gender identity are added in, so LGBT is protected, so that they are not excluded in participating in programs or benefits of such programs, activities that get federal monies. And LGBT shall not be subjected to discrimination under any program or activity receiving full financial assistance from the federal government, of course. Example, for instance, again, as mentioned, I am a volunteer in the Environmental Health Coalition, and they have for religious organizations, however. LGBT sections that I just mentioned shall not apply to religious corporations, religious associations, religious educational institutes or societies with respect to employing individuals of that particular religion to do work connected with carrying on such organizations' religious activities. G, education. Amends the Elementary and Secondary Education Act of 1965. This has its own civil rights section, and sexual orientation and gender identity are added and are to be, again, just as in Section A, as I just mentioned previously, those definitions shall remain consistent. So as what you see in the pattern, that the people who drafted this bill went for the Civil Rights Act first, and have stuck with that, and all the laws follow from then on. H, disability. Amends the Americans with Disabilities Act of 1990, the Rehabilitation Act of 1973, amended again to repeal discriminatory provisions and to delete the word transsexualism and gender identity disorder not resulting from physical improvements from exclusion. From exclusion from protection. So this goes, and this goes here. And once again, the terms of gender identity and sexual orientation are added instead. One we're all familiar with, of course, marriage equality and religious freedom repeals the Defense of Marriage Act. It defines for any and all rulings, acts, regulations, and interpretations that marriage, by definition, a legal union of two people as spouses. That's it, simple. The spouse is either a member of a legal union done by a state, municipality, any civil union, any domestic partnership, any member shall be considered a spouse. No member of the clergy of any religious organization authorized to marry under any state law shall be forced to do so for any reason, nor they shall not be forced either to marry at their grounds if it is not consistent with their religious tenets. Hate crimes. The insertion of the Matthew Shepard Hate Crimes Act would come here, in which there is any willful cause of bodily injury or attempt to cause injury due to actual or perceived religion, national origin, gender, sexual orientation, gender identity, results in imprisonment. These last two, sexual and gender identity, shall be made to go to the same definitions, again, as in Section 8, keep consistency. Okay, the armed forces. The insertion of the Military Readiness Enforcement Act of 2007, which will repeal the current military policy known as Don't Ask, Don't Tell. And this shall be replaced with non-discrimination policy on the basis of sexual orientation and gender identity. And those prior to this change who were tossed out can apply for reassessment if they wish to do so. Protections for those who are considered transgender in this case, which is what we're going for also. Now, immigration. United America's Families. To insert the Uniting American Families Act of 2007, which allows for legal permanent residents or U.S. citizens to sponsor a foreign-born permanent partnership meant to encourage family unification regardless of orientation. Permanent partnership is not the equivalent of marriage due to DOMA, if it's a marriage act. The burden of proof is on the couple to show to the government that their relationship is a true one. Now,